SJC-11970, Commonwealth v. Imran Laltaprasad.
Mr. Maxim. What a wonderful name for a lawyer, Mr. Maxim.
Thank you, Your Honor.
You may proceed.
Good morning, may it please the court. My name is Tom Maxim, and I'm an assistant district attorney from Middlesex for the Commonwealth. This is a case about following the law. This is not a case about what the law should be as a matter of public policy. That's a question for the legislature. It is the legislature that determines penalties for crimes, and it is the legislature that amends those penalties as a result of the evolving views of their constituents. And in this case, the legislature did not provide authority for the sentencing judge to depart from the mandatory minimum sentence of 3.5 years. Rather, the sentencing judge had discretion to impose a sentence anywhere between the 3.5-year mandatory minimum, going all the way up to a 30-year penalty by imposing the maximum penalty for each crime to be served.
Is that because you're relying on our decision in Russo to define the pertinent statutory provision on which you probably are relying?
Well, we do rely on Russo to say that the defendant's interpretation of 211E, Section 3E, does not provide a judge with authority to depart from the mandatory minimum sentence.
Why, exactly?
Why? The reason
Seems to be a sentence that isn't connected to a requirement of the existence of guidelines.
211E, Section 3E was passed to, or 211E, Section 3 was passed to direct the Sentencing Commission to create sentencing guidelines, and part of that would give the judge an ability to depart from the mandatory minimum sentence. It
was initially intended for that, and so then we have an uncodified version. It wasn't legislated, it was uncodified. Do you think there's a difference? In Chin, we decided there was a difference between an uncodified version of proposed legislation and then subsequently codified legislation?
Absolutely not, Your Honor. The language in this case is exactly the same as what was interpreted in Commonwealth versus Russo.
That make the difference?
I'm sorry, Your
If
Honor?
it's identical language, but one was codified and one was not, that's the difference? The language is the same?
The language is the same.
And so that's the end of the discussion?
That is not the end of this discussion. There are many more reasons why Commonwealth
But
versus Russo.
that's not actually, I mean, the particular language you're focused on here may be the same, but wasn't there a rather substantial difference in that the earlier statute said that the minimum the guideline range may not be less than the minimum mandatory, and the revised statute expressly said that it may be below the minimum mandatory, which was the reason Governor Weld vetoed it, and the veto was overridden.
Yes.
Is your view that that has no consequence in terms of our evaluation of what the legislative intent was here?
That has no influence on this case, Your Honor. In terms of the governor's veto, the governor was concerned about the sentencing guidelines providing authority for a judge to depart from the mandatory minimum. When applying the sentencing guidelines, the governor was not concerned about a judge's authority to depart aside from the sentencing guidelines.
What though, I mean, in the 93 Act, it said that the Sentencing Commission was to produce the sentencing guidelines within a year, and it had the same provision about effective when enacted. But here, there is no time that says, I don't think, that they are to be produced within X amount of time. And it also, and the fact is, if you read 3E, there are indeed, there are sentencing guidelines. I mean, they exist. They have not been enacted under law, but they exist.
Yes, Your Honor. Regarding Your Honor's first point, the reason there is no direction for the Sentencing Commission to create sentencing guidelines under 211E3 is because they were already recommended by the Sentencing Commission under the 1993 version of the statute. So there was no need to direct the Sentencing Commission to create the sentencing guidelines altogether again. So turning to Russo, this court...
Mr. Maxim, before you go there, I need help understanding why we should ignore the language in 3E. What's your explanation for that?
Your Honor, this court would not be ignoring the language in 3E by making it contingent on the passage of the sentencing guidelines. And
Where does it say that?
It says that just based on the plain meaning, and Russo found as much. Russo found no ambiguity in the statute by looking at that exact same language. They looked at the plain meaning. They also concluded, as they did in Russo, by avoiding absurdity, and as they put it in Russo, was avoiding illogical results. And also, Russo said that this was a common sense conclusion based
So
on.
what's your plain language argument that that's not what it means, that it doesn't mean what it says? What's your plain language point there?
My plain language point.
How do I get there from here?
My plain language point, Your Honor, is that the defendant's reading is based on an isolated reading of the statute. Looking at the statute as a whole, it's very clear that 3E is contingent on the passage of the sentencing guidelines.
But look at A. I mean, A says exactly that. It's the Sentencing Commission shall recommend, and they shall take effect only if enacted into law. Isn't that right? And they haven't been enacted into law.
Exactly, Your Honor. And turning to the rest of the plain meaning of this language.
Right, but the minimum mandatory is wholly separate from the sentencing guidelines. And the latter statute expressly said that the sentencing guidelines may be below the minimum mandatory. So why do you say they're intrinsically connected, especially with the revised statute?
Well, if this court looks at subsection H of 211E, section 3, that requires the sentencing judge to use a sentencing statement or to fill out a sentencing statement when making such a departure. And that sentencing statement under the statute is to be applied when applying the sentencing guidelines. So it makes no sense that a judge, that this sentencing statement that is required to be used when applying the sentencing guidelines has anything to
in cases other than the minimum mandatory.
Yes, Your Honor, precisely. And so turning to Russo, there are...
But I'm sorry, I mean, I understand what H says, but under this revised provision, a judge, if the guidelines had been enacted, could have imposed a sentence below the minimum mandatory, but within the guidelines, and would therefore not need to go to H unless the legislature expressly said, if you go below the minimum mandatory, you still must explain why you did that, correct?
Yes, Your Honor, but H is intended to be, the sentencing statement in H is required to be filled out when, in all cases, when applying the sentencing guidelines. And when this court is looking at the same language that was interpreted in Russo, it should receive the same meaning. And also, when the legislature adopted that same, when the legislature passed 211E, Section 3E, using the same language that was constructed in Russo, that the legislature adopted this court's construction of that language. Now, the defendant argues that Russo should be examined based on what they perceive to be legislative inaction on the issue of sentencing reform. This argument is incorrect for several reasons. First, the legislature has been acting on sentencing reform. The very mandatory minimum sentences involved in this case were reduced in 2012 from 5 years to 3.5 years. Currently, the legislature is considering bills to eliminate mandatory minimum sentences for certain nonviolent drug offenses. That's House Bill 1620, as well as Senate Bill 786 of this term. Additionally, there's a House Bill 1458.
But I'm lost here. Certainly, this court would never say the legislature is too slow to make a policy change, so we're going to make it for them. The argument here is that the legislature did this, not that we should do it for the legislature. The argument is the legislature already did it. So I don't understand why you're speaking of potential changes in the minimum mandatory laws as bearing on the issue of what the legislature did when it enacted the revised 211 Section 3E, which was in, I believe, I'm trying to think what year that was.
96.
96. I mean, don't we need to focus on what the legislative intent was in 96?
Yes, Your Honor. And the legislative intent in 1996 was to form a sentencing commission and direct it to create sentencing guidelines, which at that point had already been created, and it codified that language in 211E, Section 3.
Do we have legislative history?
I don't have any for this court, but however, the sentencing statement that was, or I'm sorry, the no, Your Honor, I don't have any legislative.
So you haven't, have you looked to see if there's legislative history?
I haven't looked to see if there's legislative history. I have looked at prior versions of this language from the 1993 version of the statute, Your Honor.
Do you know why, given the 1993 version of the statute, what the answer to this may be no, because you haven't looked for the legislative history, but what was the reason for redoing sort of repeating all this language in 211 in the 96 version?
It's unclear why the legislature ended up putting this into the general laws. One reason, actually, is that it appears in Title I of Part 3 of the Massachusetts General Laws. And in that title, each chapter has to do with the administration, the function, and the purpose of various courts and court officers in the Commonwealth. And the Sentencing Commission is but one of those court officers in the Commonwealth. There's a chapter on this court, there's a chapter on the appeals court, there's a chapter on the district court, there's a chapter on the superior court, as well as CPCS. And putting this in the general laws in that place simply codifies the function and purpose of the Sentencing Commission within the general laws amongst the other courts and court officers within that title.
So you think its placement in the legislation is significant?
Not in the interpretation of 3E in the sense the defendant remarks, but it is significant in the sense that Title I of Part 3 has to do with the purpose, the function of all these courts and court officers. And it's very strange, it would be very strange, for the legislature to give a sentencing judge authority to depart from a mandatory minimum sentence aside from the sentencing guidelines and aside from the Sentencing Commission at all in the chapter that has to do with the Sentencing Commission, where there's a chapter on the district court as well as the superior court. It makes no sense.
Was there some kind of a celebration in the media when the current version of the statute was enacted in 1996, saying, for instance, by defense lawyers and certain judges, saying, this long-awaited discretion in undercutting minimum mandatory sentences has finally occurred? Was there any kind of a celebration like that in the media that expressed a general understanding of the meaning of this statute as having changed prior practice?
I'm not aware of what the media was saying at that time, Your Honor. However, if they did say things favorable about the statute, it would reflect the statute moving toward individualized sentencing based on sentencing guidelines and based on various parties coming together in the Sentencing Commission to develop them, giving judges authority to depart when applying the sentencing guidelines under limited circumstances. And I would note that the current bill before the legislature to enact the sentencing guidelines, or where the sentencing guidelines are being considered, it allows for departures in certain mandatory minimum sentences, such as drug offenses, while precluding them entirely for other offenses, such as firearm offenses, such as offenses involving the exploitation of children and adult prostitutes.
This is the guidelines that have been promulgated, you're saying?
They haven't, these are the...
I didn't say enacted, this is what the Sentencing Commission has adopted?
No, Your Honor. There's the 1996 report to the General Court, and then currently there's a bill that the legislature is considering.
But we're looking at what the legislature did in 1996. I mean, isn't that the issue? What did the legislature intend to do in 1996? Why does it bear on what they're doing today?
Because it reflects that the legislature did not intend to give judges unbridled discretion on the issue of mandatory minimum sentences when they are continuing to enact them and amend them, and they're taking an offense-based approach to mandatory minimum sentences, including in House Bill 1458, which does not allow for mandatory minimum sentence departures in all cases.
So what meaning do you give to the fact that the legislature overrode Governor Weld's veto on the issue of mandatory minimums?
The meaning to that is that the legislature wanted the Sentencing Commission to look into the issue and recommend sentencing guidelines that have the ability to depart from mandatory minimum sentences. And, Your Honor, there are several constitutional issues. Regarding the selective enforcement claim, I wanted to say that that issue is not, the remedy for that issue is not affirming the sentencing judge. It would be dismissing the complaint. It's separate and apart from the equal protection claim, which challenges the statute. And where the remedy is different, it would not be appropriate to consider that in this case.
All right, thank you.
Thank you, Your Honor.
Thank you, Mr. Chief Justice, and may it please the Court, Matthew Siegel with Adriana Lafay and Keith Nicholson for Mr. Laltaprasad.
Could I just ask you one factual question? Were the sentencing guidelines that were recommended to the general court in April of '96, did they reflect the new the 1996 statute? In other words, were any of the guidelines, did they go below the mandatory minimums in any way?
Well, I think that's a complicated question, Justice Botsford, and it seems like, by and large, the Sentencing Commission didn't choose to exercise its authority, and there's some reason to believe that it was a harshness of the proposed guidelines rather than any second thoughts about the below minimum authority that was enacted in Section 3E that ultimately caused the guidelines not to be enacted, so which supports our view of the law. And speaking of which, I mean, this is a case about following the law.
Well,
but
so 20 years later, oh my God, all along, holy mackerel, right there. We didn't even know it. No judge ever knew it. This judge doesn't even cite to it.
Your Honor,
That a little inconsistent with, well, the legislature clearly intended to allow judges the discretion to go below mandatory minimums.
I understand.
Without sentencing guidelines enacted.
I appreciate the question, Your Honor, and I think there is something to the point
I think
that,
so too.
But it's not about intention; it's about expectation. The defense bar, like and other members of the bar, like the legislature, may well have expected that the guidelines would be enacted, but none of those expectations, and maybe someone should have brought you a case before now, in which case, maybe that's a problem. But the problem doesn't affect the meaning of the language that was enacted in 1996.
Let's look at the language of the 1993 Act. I think, maybe I'm misreading this. It says the sentencing judge may depart from said range and impose a sentence below any mandatory minimum term prescribed by statute, as long as they, document the reasons. Okay, well, we said, interpreting that language as well, that's all very interesting, but the whole premise of this is that sentencing guidelines are enacted, and until they're enacted, this doesn't operate. And so 1996 has very similar language. Why should we now say, well, this is now a whole new world?
Right. So there are two fundamental reasons why, Your Honor, and they both follow directly from the ordinary rules of statutory construction. I mean, this is, like I was saying, this is a case about applying the law, but the Commonwealth's argument just skipped past the rules that we use to interpret laws.
And we did the same thing in Russo? We just skipped past that?
No, Your Honor. There are meaningful distinctions between the language at issue here today and the 1993 law. And on top of that, there is different legislative reaction. So the first, one of the first rules of statutory construction is to start with the plain text, as Your Honor just did, and to save that text whenever possible rather than destroy it. So what happened in Russo is the court answered two questions. The first question was whether the legislature intended to authorize below minimum sentencing. The answer was yes. The second was whether that intention had at that time amended substantive law. The answer was no. And then
It had to await the promulgation of sentencing guidelines.
Well, with respect, Your Honor, there's more than one way to skin a cat. So one way they could have turned that into substantive law would have been by enacting the guidelines. But another way they could have turned it into substantive law was by actually turning it into substantive law, which is what they did.
I really don't think that the fact that it wasn't made part of the general laws means it isn't substantive law. Is that the argument you're making? That it wasn't put into one of the general law sections?
That it wasn't codified, Your Honor. And that follows directly from your recent opinion in Chin. It also follows from the
Besides
site.
Chin.
Well,
I mean,
then there-
there's a lot of times where we pay a lot of attention to session laws.
Right.
All the time.
It also follows, again, part of what I'm doing here is talking about the holding of Russo, but also the question is how to interpret the reaction to Russo. So what the legislature did was to enact the law. The other data point in Russo is that Russo cited two provisions that the court believed had modified substantive law. And all of those citations, this is footnote 2 in Russo, were to codified sections. And then the legislature codified Russo.
So are you saying that the 96 enactment was a response to Russo?
I'm saying I'm willing to assume that for purposes of the rule.
Have you done legislative history research?
Yes, Your Honor. And there is no indication one way or the other whether the legislature was aware of Russo. I'm just giving all benefits to the Commonwealth, willing to assume for purposes of the ordinary rules of statutory construction that the legislature was aware. But that's merely an assumption. I mean, and also, let me just take a step back. We are talking right now about plain meaning. But another important rule of statutory construction is that any ambiguity in a statute is to be resolved in favor of lenity.
While we're on statutory construction, let me just say that I know you realize you probably have an uphill battle here selling your argument. You know, you're trying to sell old wine in a new skin, so to speak. So, and we do have this rule of construction that, yeah, plain language, unless it leads to an absurd result, which the argument could be made that if the legislature had intended for judges to be able to exercise this authority, they wouldn't have hidden it in Section 3E. We would see it more prominently displayed elsewhere. So how do we get past that to make sense of your argument?
Let me respond to that specific question about the statute, but let me also respond to the more fundamental question about wine. So, on the statute,
drink too much.
We know.
You get my point about the.
I do, but I think that goes to my response to Justice Cordy. That's about whether someone should have brought you a case sooner, not about whether.
Case of what? I like red.
Anything it takes to win. But on the narrow question, Your Honor, we know that the 1996 legislature knew how to write statutory language hinging on the codification, on the enactment of guidelines. It did that in 3A1. It did that in 3G, in 3I, and 3J. It didn't do that in 3E. And what that means is the statute that you're dealing with, that you're interpreting now in 2016, is at best ambiguous for the Commonwealth. There is simply no way to read the statute to say that it unambiguously closes the safety valve until the guidelines are enacted. And that goes back to the point about wine. Because what the rules of construction say is you're to resolve ambiguities in favor of lenity and against reaching serious.
There's no ambiguity. I mean, the first rule is you look at the language and then you look at the statutory scheme. And we said in Russo, Section 3 is all about this process of preparing and approving sentencing guidelines and then how judges will use them as they intersect with mandatory minimums. That was the whole purpose. That's the statutory scheme, to be triggered by the sentencing guidelines. And you're saying, oh, no, don't pay any attention to the triggering thing here. Just focus on this little piece in here.
Well, there is more than just that. There is also in Section 2 the reference to the fact that there may be an absence of applicable sentencing guidelines, and then the court shall impose an appropriate sentence having due regard for the purposes set forth in Section 2, which include findings there exist or one more aggravating or mitigating circumstances that is then repeated in Section E.
Yeah, that point, Your Honor, is that it was never going to be true, whether the guidelines were enacted or not, that mandatory below minimum sentencing would occur only when a judge was departing from a guideline, because there were going to be crimes for which there would be no guidelines. There would be crimes for which the guidelines could be below the mandatory minimum.
But here, the whole, we're talking about a whole range of statutes with criminal punishments in it. And all the subsections, as you've read it, talk about if the guideline, the judge's authority being dependent upon the guidelines being accepted or enacted into law. I mean, wouldn't the legislature have said something like, except as otherwise provided in Section 3E, the guidelines are going to be applicable to all statutes, all criminal statutes. Here, it's one of the most significant and outstanding criminal punishment statutes, the mandatory minimums. They're slipping through under the cover of night, and that's just highly unusual.
Oh, not at all, Your Honor. First of all, Governor Weld himself said that the statute undermined mandatory minimum sentencing. That's in the statement that he issued.
Well, he preferred not to allow any authority to going below mandatory minimums.
Right. But I think what all these questions are driving at, Your Honor, is that there may have been an expectation that the guidelines would be the trigger. But the question for a court is, when the trigger hasn't happened, what is the most faithful interpretation of what is left? And the rules of construction say that the next step is to save statutory text rather than destroy it. And that's the discussion. That's the point about the wine, okay? Because when the court applies the rule of lenity, when it applies the canon of constitutional avoidance, what it is saying is turning it over to the legislature. And if the legislature concludes that this legislature, the current legislature, concludes that the safety valve that was in fact enacted and codified in 1996 is not right, is too broad, shouldn't be the law, then there could be another case that would require the court to consider the constitutional issues, which are serious. It is impossible to say, given what has been shown to the court about the racial disparities, about the absence of any meaningful public value added by mandatory minimum sentencing, that someone who comes to you and says there's an equal protection problem with these statutes is being unserious.
Well, the application of the statutes by various district attorneys' offices. There's nothing wrong with the statutes themselves.
That's not true. We do have a disparate, there is evidence that it is not true, which is before you. In this respect, we do have a separate disparate enforcement claim, which is in part 2 of our brief. But in terms of the canon of constitutional avoidance, the court can consider that recidivist enhancements, school zone laws, have been shown to be major drivers of racial disparities, and that a safety valve, which would permit, as Judge Friesen did in this case, a judge to avoid those drivers as being the sole determinant of someone's sentence.
But isn't that a legislative determination?
Yes, Your Honor. It was a legislative.
In the school zone case.
I'm sorry, Your Honor?
In the school zone case, that was all about a legislative determination and us interpreting whether they intended to make it retroactive.
That is right.
The constitutionality.
I think if I understand Your Honor's question, you're referring to the Bradley decision, right. And that is a perfectly good example of a case in which the court relied on data about racial disparities.
No, relied on the fact that the legislature was relying on that information to modify the statute so it wouldn't discriminate against urban dwellers and therefore against minorities.
And
a legislative act.
And that is what happened in 1996 as well, in that the legislature was focused on the ills of mandatory minimum sentencing.
In 1996.
But how do we know that without some more legislative history? I mean, that's the. I mean, I'm not even sure if we even know what the context is. Are you saying that the guidelines had been prepared by 96, that they were available to the legislature in 96? Or that they were still being readied?
I think they were still being readied by the time this was enacted. But in terms of the what the legislature was thinking about, I mean, we look, first of all, to the text, but there was a Globe Spotlight investigation on the ills of mandatory minimum sentencing. There was the Flaherty Commission study. But the more fundamental issue is that in the Bradley decision, which Justice Cordy has been referencing, that was a case where the intent of the legislature to avoid some of the problems with mandatory minimums was deemed to overcome a legislative presumption against prospective application of a new law. Here, there is no presumption going against us, as there was for the defendant in Bradley. There are these various canons that cut in favor of lenity.
On the lenity question, I'm just interested if you have any other case in which, or situation in which the rule of lenity has been applied in interpreting a statute that isn't setting a sentence or defining a crime or something like that, that applies to an individual, but is a statute that is saying, you know, either a judge can do this or a judge can't. I mean, it seems at least one step removed from where the rule of lenity, you know, its home is.
If I understand the court's question
I'm not saying it
correctly,
very well, but
I have two responses.
It just
Right.
seems sort of abstracted away from the circumstance that the rule of lenity, I think, really addresses.
Well, here's what I just want to review the bidding. Here's what we know, is that based on the court's decision in this case, it will either be the case or not that 70% or more of mandatory minimums will be applied to people of color this year and next year and the year after that. And the question is there statutory language which compels the court to do that? And the answer is plainly no.
Do you know whether or not any legal commentators or law review articles had been written about, consistent with your interpretation in the last 20 years?
I'm not sure the answer to that question, Your Honor, but I would say, partly in response to your question and partly by way of responding to what I perceive to be the second half of Justice Botsford's question, what is a situation like this? And again, I think what we're coming back to again and again is that the expectation that the guidelines would be enacted weren't met. And that kind of thing happens all the time. For a long time, people thought that the Sixth Amendment right to a jury trial, right to confrontation meant one thing, and then suddenly there was a change in the law and it meant something else. And that's the kind of situation we're dealing with here. It's also the kind of thing that arises all the time in statutes. The Congress enacted the federal sentencing guidelines, thought they were mandatory, no thought given to the idea that they would be advisory. And yet that provision, the mandatory aspect of those guidelines, was deemed to be unconstitutional in a revolutionary decision that few saw coming.
And for very different reasons than this.
Well, I'm not focused on the reasons. I'm focused now on what the court did next, which was to say, let's not get rid of all the guidelines, all the work, all the expectation just because one expectation wasn't met. Let us keep the guidelines in advisory form. And the question here is whether we're going to get rid of something that the legislature actually enacted into law.
So you said unless we act here, next year 70% of all the mandatory minimum sentences will be imposed on minorities. So are you suggesting we now abolish mandatory minimums so they no longer exist?
I'm suggesting that if the court concludes that the law that we're relying on doesn't apply, then yes, you should strike down the mandatory minimums that have sought to have been applied to Mr. Laltaprasad because they're unconstitutional.
As applied?
No. There is an as-applied challenge, but when I say they're unconstitutional, I mean the second and subsequent offenses are unconstitutional. They are inherently discriminatory and have been shown as such.
So it's not just a question of saying that a judge has authority to sentence below. You're saying they should be stricken as unconstitutional on their face or as applied? Or?
Yes, Your Honor, but only if you don't do what I think that the rules of construction require, and this is going back to Justice Hines' question.
So we do what you say, so judges have discretion to go below the mandatory minimums. So they don't exercise the discretion. Same darn results next year, 70%.
Well, there is significant evidence that that's not going to be the case. And Judge Saris has written about this in the federal sentencing context, which is that recidivist enhancements based on criminal history are drivers of racial discrimination. That is why the U.S. Sentencing Commission has recommended that the safety valve under federal law be changed to admit more criminal history points. And removing that impediment to equal justice would significantly improve.
And that will be a big process to amend the federal guidelines.
It
a
would.
Legislative process.
It would. It would require codifying law like the one in 1996.
But if we were to consider the racial disparities, would there not have to be an evidentiary hearing below to give the Commonwealth the opportunity to address that? I mean, we don't have anything like that here.
That only, Your Honor, as to the as-applied challenge with respect to a possible disparate enforcement claim for Mr. Laltaprasad. The Commonwealth has seen the data on disparities overall, which go to the law overall, has had an opportunity to brief them, and has not even today said that we're even slightly wrong about them.
Are you asking us to do two things in this case? That is, both interpret 3E the way you're suggesting and declare that the sentence that Mr. Laltaprasad got was unconstitutional?
If you do the former, Your Honor, that would obviate the need to do the latter, because the driving reason, to interpret the 1996 law in favor of lenity and against bringing constitutional issues to a head is so that you don't have to reach that
Okay.
constitutional hold.
So-
But was this constitutional issue presented to the trial judge?
No, Your Honor. It's presented in the 211-3 process, but either way, I mean, even if you don't reach the facial challenge to the law, which is 2A of our brief, the question is, it still comes in interpreting the statute. If the court knows that one interpretation of a statute is going to raise a serious constitutional issue, as it would to close off the safety valve, then the rules of construction say choose the other interpretation.
So, one last question. Assume that the court, without saying anything about the Constitution, but adopts your view of what the statute means. So the next case, so now it's, judge can go below, and the next case that comes up, the Justice Cordy doesn't. So is that now going to be subject to a challenge that it's unconstitutional as applied? Not an equal protection, I mean, but because you're saying applying the mandatory minimum, if a judge exercises discretion, I take it your point is, because it's facially unconstitutional, that applying a mandatory minimum, even as an exercise of discretion, is going to be unconstitutional if the person happens to be a minority.
I think I can allay that concern a little bit, Your Honor, because if this court holds that the safety valve is in effect, as it's been codified, and a judge chooses to apply a sentence that is equal to or above the mandatory minimum, despite not having to do that, that would seriously undermine a facial challenge to the law. However, and the Commonwealth may also have an argument that if we're right that Section 3E's safety valve is in effect, then there is some limited right to appeal as in Section 4. So this is not a question that just leaves all doors open. It is a question about whether to put into effect a limited safety valve that is already part of the law.
Okay, thank you.
Thank you.